Ghanatube, so I was in formatting CD and not just saying some. I would be a person or my Ghana and Pano. Ye bobo room near Rockety and sending me, say a bar, not near Cowan media twice or Eddie amount.
Major cases in capital offense cases, the trial judge can get it wrong, right? And that involves somebody's life, whether they're going to be found condemned to death, or they're going to be put into prison for life. Even that is not so gross as to lead to the judge. He got it wrong. Yeah, I got it wrong. You can get it wrong, you can get it right. So that is why I keep asking, and then what happened? Because in the end, you look at the gravity of the harm that was done, if any. If any. That's all I've got to say on that.
So as far as you are concerned, that also does not meet the threshold in your definition?
No, doesn't.
Do you think, and this is just a general question, do you think from what you've heard about the allegations, it should have crossed the threshold? I mean, I've seen suggestions that you abstain from the vote at the Council of State level.
I cannot reveal what happened at the Council of State level.
The question is, do you think it crosses the threshold of a prima facie determination?
You think you can get me to?
No, my lady, it's a separate question.
You think you're separating it.
You have expressed an opinion on the three allegations that we discussed.
Yes, and so deduce. Deduce from what I've said. Yes.
Is it a fair deduction to say that your opinion is that it does not cross the threshold?
It does not cross the threshold. You know, you've already done your criminal procedure, because once you're bringing in a prima facie finding, you're sort of skirting the lines of criminal procedure more than you will be skirting the lines of civil procedure, right? Okay. And I do not think that if these were criminal allegations, any of them would cross that line whereby the case has been made out, because the part I played in this matter was only in terms of prima facie, and prima facie only had to do with the facts as they are before you, or the allegations, and any supporting material as has been presented to you. Isn't that it? So, like I said, I didn't see what is in what came before them beyond what I had earlier on seen. And what I had earlier on seen was insufficient. Yes. It didn't even cross into the inquiry stage.
So a committee, in your opinion, should not have been set up to inquire into it?
I think it follows, doesn't it? Follows.
I mean, a number of your concerns rest on a lack of clear laws in place and everything. To the extent that the committee was exercising discretion and their own understanding of some of these laws and applied it, would you disagree or agree with those who say that no clear-cut provision has been breached in terms of from the start of the procedure for the removal to their conclusion?
Well, what procedure? That skeletal framework that's in the Constitution. See, that's a very. I want to take you back to the Ajay Chum case. See, in the Ajay Chum case, the the court, matters had only just begun. The process had only just begun. So we couldn't really go deeply into other aspects that could have come up. But the court perceived, rightly so, that the procedure that has been set out for the removal of the Chief Justice fell so far from normal standard of justice that we had to read a procedure into it. For the simple reason that for the removal of a normal Superior Court judge, there's a stipulated need for a prima facie determination, and then for the removal of the Chief Justice, there was no such thing. Yes, and so we read the need for, because otherwise, why should it even go to the Council of State if it goes in and it comes out? What would have happened to it? It goes for them to look at it. So we decided that there too there has to be prima facie, because when you're dealing with constitutional processes of this sort, there are all kinds. It's nuanced, and you need to, as much as possible, shore up the provisions to reduce the room for play of nuances. You need, so as to create more certainty. I think that's the best way I can put it. We didn't get to the stage where we were to determine, okay, I am the one who speculated. It was Obita. Yeah. But the court itself did not go into the grounds sufficiently clear. We didn't go into that. But this was an opportunity for that to be also done. Yeah. I've done in connection with the article. I had to do a prima facie finding once, and I certainly decided to go to. I treated it like I'm a High Court judge who's making a prima facie finding in a criminal case, and the standard had to be really very high, and at the same time one also had to take into account the circumstances. See, because stated misbehavior simply means you're supposed to have misbehaved in this regard, but as to whether it has the weight to amount to misbehavior that should have certain consequences, that is an evaluation that is also nuanced. Yes. And in my opinion, most of the things that had been brought against the respondent, I threw them out, because de minimis non curat lex. What does that mean?
The law does not concern itself with things of trifle, not substantive matters, not little things.
Yes.
Yeah, but if I'm to ask directly, would you say that the former Chief Justice got a fair trial, if I'm to put it in that manner?
You want my opinion, you want my legal opinion, you want an opinion from the heart and the mind and the soul and the spirit. No, she didn't. She didn't. And there were also other things which in the latter part of the proceedings also happened, which you know, I don't even know how to put it, but they were very unbecoming. One, a process that is supposed to be purely in camera, and that expression in camera has been defined by the Supreme Court, and that definition still remains, right? That from the complaint all the way till the president speaks at the end of the matter, it's all what? It's all to be treated as part of the same thing. It comes under the same cover of in camera, and therefore is supposed to be confidential. So you can imagine the umbrage that I felt to receive on social media some social media thing somebody had sent to me, where the fact of which I am not in the least bit ashamed, and if I had to do the same again, I will. The fact that I had gone to give evidence before the committee was on social media. How did that get there? And it was not only myself. So and 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 so. I'm not going to repeat that. I won't use the word that came on my lips. I'm not going to repeat that unbecomingness by even mentioning the names that were mentioned. Isn't somebody entitled to have every witnesses on their behalf? And then to come to think of it, then I thought, yeah, but we don't even know who gave evidence on behalf of the petitioner. So why is it that those who gave evidence for on behalf of the respondent, why should we be thrown to the rabid dogs? Because there has to be some not very noble motivation for that. And when it says that they from quote and unquote sources close to the committee, oh really, that is so sad and it's so pathetic. And then on Sunday somebody sends me another thing where somebody's going on and on and on and on and going on about the legal submissions that had been filed on behalf of the petitioner. Really? Why? What's the game? What's going on? I felt sad, and even that in itself made me sad. Have we come to this in this country where a process, the most important thing in every process, whether it is a formal judicial process or it is the most informal process, such as, let's say, ADR discussions and all that, where something is supposed to be confidential, it has to be kept.
But to the extent that the Supreme Court has determined that if there is a breach of the in-camera rule, it does not invalidate the process, should that still be of concern?
That does not matter. I'm still talking about it. Just because it doesn't breach it, it breaches the letter. It breaches the letter of the Constitution, does it not? That it should be confidential. I'm not saying it therefore means anything, but all I'm saying is that for me it puts an unpleasant aroma onto the procedure, because process integrity is exactly that which is demanded of the most humdrum, the most mundane inquiry, let alone an inquiry into whether or not a Chief Justice should be removed or not.
Outside of that concern, what other matters constitutes the basis for your conclusion that you don't believe she got a fair trial?
Oh, I didn't say she got. Maybe what I meant is she got. After all, it wasn't a trial, even though it was handled as though it was a treason trial.
Why did you say so?
Because that's how I feel. Because that is how I feel. Am I entitled to feel? Am I?
Yes, but to the extent that the petition was sent, a committee.
Listen, a petition was sent. It went to the Council of State. It came back. A committee was set up. Yes. Then you get into the qualitative aspect of things, and you see my upset and I won't use the word anger because I don't waste my anger on certain things, but my discomfiture also arose from the fact that when the Chief Justice, and that one is a matter of public knowledge, right? When she applied that, okay, since the pleadings are all now out there in the public domain, why can't we simply have a public hearing? She was told what? No, it's supposed to be in camera. It's supposed to be in camera. Everything is confidential. So I go to an in-camera process to give evidence, and then it's out there in the public domain. Approbation and reprobation, that's the way I see it. The committee, either it was not protecting itself properly, because really, who came? Because as I was walking into that building, I didn't see any paparazzi within sight. Okay? Nor did I see any person surreptitiously maybe taking pictures or anything like that. So, how it got to the press that so and so plus me, we had given evidence, I think that is wrong, and it was in bad faith, and it was in bad form, and it was not in consonance with the due process, the due regard that is dictated by an in-camera process.
In the course of the hearings, there were a number of court decisions.
I didn't follow any of them.
I mean, the multiple attempts, and I'm asking this because some of the concerns that you've raised were all matters that were put before the courts in one form.
I did not
or the other.
Follow any of them. The few that I didn't really follow the details of them. Some of the outcomes were a little too predictable. I didn't follow because as far as I was concerned, the whole thing shouldn't have been happening in the first place. So I had shut my mind to the whole process. After all, I'm no longer a Chief Justice. My sole role in the whole matter was whatever came before the Council of State. That was passed. how I felt about it, how I didn't feel about it was neither here nor there. So why should I follow it? And at this point in time, I'm not even going to say the Supreme Court was right or was wrong, or this court was right or was wrong. That's all neither here nor there. It has happened, and all I can say is that I just pray to the Lord that no judge and no Chief Justice henceforth ever has to go through this rigmarole again. That's all I've got to say.
I was your former Namasa Mudi Mechi, Equity, and some air coso, a war or manganimu, wait, dear, Midimubesi, and as we made our comments, no. Emma may our comment section. That would be Ewan sending now no for our comments in the Ebra and Magic Bread. I can kind. Ama Fefe, make I will be set channel way, Ghanatube. So don't forget to subscribe, hit on the notification bell, share, and like all our videos. I was here for Snowy Day. Sisia dear, Macramo.